All right, we're back on the record in case number 26-90103. So what I would suggest is that rather than have Mr. Harris cross-examine the witness at this point, why don't we go on to some of the other motions, and so that you'll have time, Mr. DePompeo, to address the questions, the arguments that were made in the motion, and that way I think we'll have a better presentation, because otherwise I think we would do the cross-examination and then, take additional time. And I read it quickly, so I really didn't have a chance to really study it. So I'd like to come back to that after we do, we take another break and we go through some of the motions. I think that probably makes the most sense.
Your Honor, we can certainly do that if it's convenient for the court. We are also available and ready to respond now. These are objections that we knew were coming through prior discussions and communications with Amazon. So if it's helpful to you, we're happy to.
Yeah. I'm glad that's the case, but I'd just like to be able to read the objection a little bit more carefully than just a quick perusal through. So why don't we go through the other ones, and we'll take it up right after the next break.
Okay, thank you, Your Honor.
Your Honor, this is Chris Harris. Can we just confirm that the witness is on the stand, and so no one will be speaking to him in the interim on these topics?
Well, Your Honor, I don't think he's been sworn yet.
He hasn't been sworn yet, Mr. Harris. So.
Okay.
All right. So why don't we move on to some of the other items on the agenda, and then we'll take a break. Mr. Hawkins, did you want to say something? Wait, did you hit 5-star, Mr. Hawkins?
Your Honor.
Yes.
There we are. Thank you so much. William Hawkins from Loeb & Loeb. We represent Dolce & Gabbana and Bichego. I am admitted to the Southern and Eastern Districts of New York bankruptcy courts, but not to your fine court. I do intend to do a pro hoc vice. We just didn't have time today. I hope you'll tolerate that for this brief presentation.
Absolutely.
Two things I hope to raise as an objection, but maybe could be helpful. Both of the clients that I just mentioned have consignment arrangements with the Saks companies, and it was not clear to us that consignment, both goods and proceeds, were clearly set forth as being some of the permitted prior liens, which I believe the DIP facility, in this case I think would be ABL, is not intending to touch. That is an objection or a request for a clarification. Then with regard to Dolce & Gabbana, they have from Holdco 2 an obligation for their indebtedness. It's unsecured. Holdco 2 appears to not have much debt and is solvent going into these cases. And so we would join with the concerns that were expressed by Amazon about putting a lot of debt on that entity when right now we understand it can pay everything it owes. That's all, Your Honor. Thank you.
Thank you. Right. Anyone else wish to be heard?
Your Honor?
Yes.
Jonathan Cover again, also from Alaska for Gorski Group. Gorski Group is also a consignment vendor, and we just got to agreement with the debtors and I believe the lenders as to language that they were going to put on the record on the consignment point. So obviously this can wait, but since the consignment stuff came up, it might make sense. I'll let the debtor speak to that, but this might be a good time for it.
That's fine. That probably makes sense because that's probably somebody. I did not, Mr. Hawkins, I did not read the order to do anything with the consignments, but if there's clarifying language on the record, that would probably make more sense. I don't know.
Your Honor, can you hear me?
Yes.
This is Seth Lieberman from Prior Cashman. May I be heard briefly?
Yes, sir.
Thank you, sir. Your Honor, as you may recall, we, alongside our co-counsel, Andrews Myers, represent a number of vendors in these bankruptcy cases, LVMH, Kering, Richemont, among their affiliated brands, along with David Yearman, SMCP, and Goyard. And we filed a reservation of rights today, which I believe is at docket number 130. And I'm only raising that right now, Your Honor, because this seems to dovetail well into Mr. Covery and Mr. Hawkins' remarks. And if I may be heard, I just wanted to raise 2 points for the record.
Sure.
The first is my clients have no issues with the debtor's procurement financing. It appears there's a need for financing for the debtors to operate in Chapter 11, to pay claims of certain third-party vendors such as my clients. And to that end, we're supportive of our continued and longstanding relationship among Sachs and my clients, and trust that that will continue both during and after the Chapter 11 cases. However, the second point I want to raise to the court, Your Honor, and while we're on the topic, I just want to be crystal clear on this, is that while the DIP papers and related proposed orders certainly allude to these issues, both my clients have various consignment and concession arrangements. And to be very clear on this, Your Honor, the debtor should be explicitly carved out from any type of collateral pledge vis-a-vis concession or consignment. We believe that that's certainly the intention. That seems to be the language. But just to state the obvious for the court, Your Honor, the company can't pledge what's not theirs. The extent that there are goods or proceeds which don't belong to the debtors, or my clients have superior rights with respect to those goods or proceeds, and those concessions and consigned goods should be carved out from any collateral that's pledged. Like the other parties here, we've only had a few hours to really dive into this, and so we're still looking at it. But I just rise to not only reserve my client's rights vis-a-vis concession and consignment, but also to make the point abundantly clear on the record and request that the DIP order reflects that none of those goods, again, concession, consignment, or the proceeds thereof will be pledged as part of the DIP. And my team is happy to work with the Wilkie team on proposed language to be inserted on the DIP order to that effect. And with that reservation, Your Honor, I'm going to let everyone get to the
Your Honor, may I be taken back?
Yes.
Thank you, Your Honor. This is Jason Keough, Smith, Thomas, and Joyce on behalf of Access Scott Pirelli, SMS, which is also a consignment vendor. I did read Mr. Lieberman's reservation of rights, and I just listened to what he said, and I would like to echo that reservation of rights with respect to the consignment vendor's property interest and reserve rights on behalf of Scaparelli in exactly the same way Mr. Lieberman did, and we also would be willing to work with debtors' counsel to craft some language for the DIP order around that issue. Thank you.
Right.
Your Honor, if I may be heard briefly.
Yes, and would people please mute their lines, because we're still, although there's a lot less people than are on the line, there's still a lot of background noise. So if you're not speaking, mute your own line, please. Right, go ahead, sir.
Thank you, Your Honor. Christian Jensen, Sullivan and Cromwell, appearing on behalf of Xenia Group. I have a pending pro hoc, if I may be indulged to speak now.
Yes.
I'll just briefly join the comments made by Mr. Lieberman with respect to reservation of rights. My client and their, its affiliated subsidiaries are party to similar concession agreements. We fully agree that the DIP cannot grant liens on inventory that the debtor does not own. But that, for avoidance of doubt, any concession inventory should be fully carved out of any DIP liens. Additionally, my clients are creditors at Holdco 2, and we join the comments made by Mr. Hawkins and others with respect to the DIP financing at that entity.
All right, thank you.
Your Honor, may I be heard?
Yes.
Brendan Scott, Clayset, Winters, Driller, Southern Stevens, on behalf of BH Multicom, BH Multicolor, Richline Designs, and Unique Designs, also a group of consignment vendors. Rather than duplicating the argument, I'd just like to say that we do echo the sentiment of Mr. Lieberman, and we join his reservation with respect to consignment. reservation rights with respect to consignment goods. We have sent over some proposed language to the debtors earlier today and hadn't received a response. We're happy to hear what the debtors are proposing on the record now. Thank you.
Right. Anyone else wish to be heard?
Yes, Your Honor. Justin Bernbach of Shepherd Mullen.
Hey, go ahead, Mr. Bernbach.
Thank you, Your Honor. Again, for the record, Justin Bernbach, Shepherd Mullen, Richter, and Hampton, counsel to Chanel, Acris, and Ralph Lauren. We'll have notices of appearance and PROHACs filed soon. Your Honor, I join Mr. Lieberman's comments with respect to concession and consignment. As the others have mentioned, Chanel in particular has a significant concession relationship with these debtors. It's a relationship that has been strained, as is evident by the top 30 list of unsecured creditors. But nevertheless, Chanel is very encouraged by the commitment by Mr. Britton's clients. Nice to see Mr. Britton. And Chanel stands by these debtors, Your Honor, and is prepared to support them through these Chapter 11 cases to the greatest extent that they can. With respect to Acris, Acris also has a Holdco 2 guarantee. Acris does not join the comments made by counsel to Dolce. And indeed, Acris and Ralph Lauren and Chanel would like to see this DIP approved today. Thank you, Your Honor.
All right. Anyone else wish to be heard?
Your Honor, can you hear me? It's Greg Gallardi.
Yes, Mr. Gallardi, go ahead.
Your Honor, just very briefly, representing Centric and Vince, I just wanted to again express our concerns about the DIP. We are creditors given credit support by the Holdco 2 entity, and we're reserving rights to potentially cross Mr. Weinstein if we think it necessary. Thank you.
All right, thank you. All right, if anyone else wishes to speak, hit 5* one time.
Good afternoon, Your Honor. Can you hear me?
Yes, I can hear you, Ms. Heilman.
Thank you, Your Honor. Just for the record, Leslie Heilman from Ballard Spar on behalf of a number of the debtors' landlords. I just rise because we do have, as is customary, we have reached out to the debtors and have worked on some resolution of our customary issues to the DIP order or the interim DIP order, but one issue does remain open, and at the appropriate time, we would like to raise that objection on the record, and I would imagine that it would be more after Mr. Weinstein's testimony, but we do have one open issue, and since parties have been stating on the record their concerns with respect to the DIP, I just wanted to make sure that at the appropriate time we could be heard on that issue.
All right, and what issue is that?
The issue is with respect to the debtors. The DIP lenders are seeking a waiver of the 506C, 552, and marshalling waivers on the first day of the case, Your Honor.
Okay. All right. All right. Anyone else wish to be heard?
Your Honor, if I may?
Yes.
Good afternoon or good evening, Your Honor. Dan Fiorello from Ottawa, PC, with me, Dave Castleman. We're co-counsel to Bank of America, the administrative agent for the ABL Bank Group that provides the ABL revolving line of credit and proposed DIP lender. Your Honor, I'll defer to the debtors' counsel to read on the record language that we've agreed prior to the hearing with regard to the reservation of rights on the consignment and concession goods, and we support the reservation of rights. Your Honor, today we're not trying to adjudicate the priorities of the consignment vendors or the concession vendors. We're merely looking to reserve rights for today's hearing, as evidenced by the appearances by multiple counsel on the first day. We anticipate that between now and the final hearing, we'll have a lot of conversations and engage with the company and the consignment and concession vendor counsel to reach acceptable language that will get folks comfortable. But, Your Honor, we are, in fact, a bank group of over 10 banks providing significant liquidity and proposed liquidity in the Chapter 11, and we're merely looking to continue the same ABL revolving line of credit that the company has had access to for years prior to the bankruptcy filing. And we're just trying to preserve the status quo for now, Your Honor, and to the extent parties cannot reach a resolution on consensual language that would be reflected in the order submitted for final approval, then we would obviously, everyone's rights are reserved with respect to the final hearing on the matters concerning the consignment and the concession priorities and interests.
All right. Why don't we hear from the debtor, and then let's try to move on to some of the other matters, and then we'll come back to the DIP in short order.
Good evening, Your Honor. Robin Spiegel, Wilkie Farr and Gallagher. You can hear me okay?
I can hear you fine, yes.
Great, thank you. The vendors, whether they're wholesale, consignment, or concession, are obviously very important to the debtor's business. Ms. Sinclair went through that in her opening remarks. In anticipation of potential objections, at least on the interim order, we had included paragraphs 27 and 28 of the DIP order. In paragraph 27, it talks to the consignment inventory and specifically reserves rights of consignors. We did agree just before I got up with one of the consignors that we would read on the record that the parties' rights as to the priority of their liens, including purchase money interest, security interest in consigned goods as against DIP collateral, are preserved. So that, combined with 27, is intended to preserve the rights of consignment vendors. And as Mr. Fiorello said, we will work in the interim with all of the consignment vendors that reach out to us to try to come up with some consensual language to include in the final DIP order. With respect to the concessionaires, we did include language in paragraph 28, which we think should address their concerns. We've heard them on the record. They'll have a chance to look at it, but if there are issues, we will work consensually with them going forward.
All right, thank you.
Thank you. Good evening, Your Honor. Jessica Graber for the record. Wilkie Farr and Gallagher, co-counsel for the Global Debtors. Can you hear me okay?
I can hear you fine, yes.
Thank you, Your Honor. I will be starting with agenda item number 6, which is docket number 13. This is the Global Debtors' motion for authority to continue using their existing cash management system, including bank accounts and business forms, to honor certain related pre-petition obligations and to continue intercompany transactions in accordance with their pre-petition practices. As noted by my colleague, the Global Debtors refers to all of the debtors except for debtors that comprise the Saks Office digital debtors. As Your Honor has heard, the Saks Office digital debtors, who maintain their own cash management system, will be seeking relief pursuant to their own separate cash management motion. As described in the motion, the Global Debtors utilize and maintain a global cash management system that is comparable to centralized cash management systems used by other large retail companies. The global system is actually comprised of two largely separate systems that interact in a centralized manner. First is the Saks Legacy Cash Management System, and the second is the Neiman Marcus Cash Management System. Although the entire system is comprised of almost 227 bank accounts across 11 banks, the movement of cash throughout the global system is not overly complex. The global cash management system generally involves the flow of funds through various Saks Legacy and Neiman Marcus receipts and deposit accounts. There are also accounts that serve other specific purposes, such as investment accounts, accounts that make disbursements specifically related to real estate obligations, master funding accounts that receive and transfer funding distributions that the debtors receive under their legacy revolving credit facility as well. Finally, the vast majority of the global debtors' bank accounts are store accounts, which are held at various banks. A critical component of the global debtors' cash management system is the routine and ordinary course intercompany transactions that the global debtors engage in with each other, and also with certain of their non-global debtor affiliates. The nature of these intercompany transactions are described in more detail in the motion, but they relate to payments of rent obligations to the Saks flagship location, a sharing arrangement between the global debtors and the Saks Office digital debtors, and the payment of certain rent obligations. As described in the motion, if these ordinary course intercompany transactions were discontinued, the cash management system, as well as the global debtors' broader business operations, would be severely disrupted, to the detriment of the global debtors, their estates, and their creditors. Accordingly, the debtors are seeking authority to continue engaging in the intercompany transactions consistent with their pre-petition practices. And as set forth in the motion and as required under the proposed order, the global debtors will maintain detailed and accurate records with respect to all intercompany transactions and transfers. A final point on the cash management motion, the global debtors are requesting an additional 45-day extension of the requirements under Section 345B and the trustee guidelines with respect to their bank accounts so that they can work with the U.S. trustee to confirm compliance of the global debtors' bank accounts. We do have a handful of revisions that we plan to make to the cash management order and related Exhibit 2 that was filed with the motion. It appears that certain language pertaining to the global debtors and the Saks Office digital debtors payment arrangement was stripped from the as-filed order. As a result, we plan to submit a revised order that includes language to this effect, which I'm happy to read for Your Honor.
Well, just make sure to file a red line, and I'll review the red line as well.
Thank you, will do. Additionally, there were a few bank account numbers that were inadvertently excluded from the list of bank accounts set forth in Exhibit 2, which we will fix as well. Prior to filing the motion, the debtors previewed the requested relief with the U.S. Trustee's Office, answered certain questions, and I understand that we are resolved on the questions they posed, and the U.S. Trustee does not object to the order. Unless Your Honor has any questions, we respectfully request that the Court approve the cash management motion and enter the order.
All right. Does anyone wish to be heard with respect to the cash management order? Yes, go ahead.
Your Honor, Amine Bordi from Exonic. Absolutely no objection to cash management other than we would like to reserve rights, which you'll hear in connection with our DIP presentation about debtor separateness. So as long as all of the first days are going to be without prejudice to our rights and arguments in that regard, I won't raise my hand again until we get to the DIP.
All right. Ms. Reckler.
Thank you, Your Honor. Caroline Reckler on behalf of Amazon. Your Honor, before the hearing, we had asked the debtor to include some language in the order that said that the debtor shall maintain a report setting forth all the intercompany transactions involving Saks Fifth Avenue Holdco 2 LLC, Saks Flagship Real Property LLC, and or 12 East 49th Street LLC, and to provide us with a copy of that report on a weekly basis in addition to providing it to our creditors committee. And we just asked that the debtor include that language in the revised proposed form of order.
All right.
And we would join in that request.
All right. Any objection?
The debtors do not believe that there is any basis for Amazon and Exonic to be receiving those type of reporting, so we do object to that inclusion.
All right. So I think subject to a appropriate confidentiality agreement that it can only be used for purposes of monitoring the cash management, I think that so long as there is an appropriate confidentiality agreement that they can't use it other than for purposes of monitoring it, and they can't disclose it except subject to further court order, I don't think that's a bridge too far. And but that I'm going to draw the line at that. To the extent everyone else asks for it, then we're going to go back and just give it to the creditors committee, and they can inform creditors appropriately. Go ahead, Mr.
Your Honor.
Yes.
Sorry, again, Dan Fiorello from Otterberg PC, counsel for Bank of America as agent for the ABL lenders. Your Honor, some of the banks in the ABL bank group also provide cash management services. I just raised a concern regarding disclosing information relative to the cash management systems that some of these banks have with the debtors, insofar as there may be confidential or proprietary information that may not be intentionally disclosed, but may be in violation of the bank's arrangements with the company. And so I don't want to have an agreement on the record that might put the company in jeopardy in violation of their arrangements with the banks.
And I think all we're talking about is not so much the intercompanies, but the transfers between debtors, and they can. It doesn't have to show what bank or anything. It's just debtor 1 to debtor 2, debtor 2 to debtor 3, and it's all with respect to the debtors that Ms. Reckler has a concern about. I mean, that's all we're talking about. It's just a limited universe of those transactions. I don't believe, obviously, to the extent that there's an issue with that. I mean, this is not an issue with respect to the form of order. It's just something that can be worked out in the ordinary course. So, and there's going to have to be a confidentiality agreement entered into and everything.
Thank you, Your Honor.
All right. Anyone else wish to be heard on cash management? Mr. Wynn, are you?
Your Honor, briefly, William. Yep. Can you hear me, Your Honor?
Yes. Yes, sir.
Good. William Hawkins again, briefly. We just wanted to make sure that nothing that is brought forth in the cash management order compromises the ability to keep cash proceeds traceable and identifiable from the various consigned goods. Either money they may have now, especially because after the holiday season there were presumably a lot of sales, as well as going forward. That was the substance of that.
Yeah. So with respect to the cash management, I view that as strictly as a procedural order that continues to allow them to implement. The bankruptcy code requires that you close all bank accounts and open up new bank accounts, and this allows the debtor, the cash flows of the debtor to continue uninterrupted. I don't view this as a substantive consolidation or anything other than allowing the debtor to continue to operate in the ordinary course, and now that they're in bankruptcy, and I'm sure they did before, is account for all of the receipts and all of the intercompany amounts. So I don't view this as in any way impacting the concerns that you have. But I'll let the debtor address that, but that's the way I read the order.
Thank you, Your Honor. That's correct.
All right, so should we talk about the final hearing?
Sure, Your Honor.
My understanding
I believe that there were
February 13th.
Yes, I'm sorry.
February 13th. I think that's what was discussed with Mr. Laws.
Yes, I believe that's correct, Your Honor.
Okay, so February 13th at 9 a.m. Central Time, and that hearing will be a virtual hearing as well.
Thank you, Your Honor.
All right, and so the objection deadline would be the Friday before, the February 6th. So if you could just work that into the proposed form of order that you upload.
Will do. Thank you, Your Honor.
All right. So based on the testimony provided in Mr. Weinstein's declaration regarding the cash management system, I'm going to go ahead and approve the order, subject to the subject to the comment I made with respect to the accounting for the intercompany amounts. And with that, once the order is uploaded, I'll enter it and go forward. All right. So that order is granted subject to the presentation of the new form of order. All right. Where do we go next?
Thank you, Your Honor. Next up is agenda item number 7, which is the wages motion. This appears at docket number 10. Through the wages motion, the debtors are seeking authority to continue certain employee benefits in the ordinary course and pay certain pre-petition claims owed to their workforce, both subject to the terms of the proposed order. The debtors currently employ almost 17,000 employees across the United States and abroad, all of whom are vital to the debtors' continued operations. The motion describes the debtors' employee obligations and programs in detail. This information is set forth and summarized in paragraph 18. A large portion of the cap amounts accounts for health and welfare benefits, including medical and other benefit plans offered to employees, pay time off, and outstanding leave obligations, as well as retirement benefits. A significant yet smaller portion of the amounts requested relate to pre-petition compensation obligations owed to the debtor's workforce, including temporary employees and commissioned employees. And the remaining portion of the amounts requested relate to withholding obligations, including union deductions. Approximately 6,000 of the debtor's hourly-based employees are eligible to earn commission, which makes up a large majority of those individuals' wages. The commission program is primarily available for certain employees in sales and sales support roles, and the amounts earned are paid as part of the employee's regular payroll disbursement. As part of the relief requested, the debtors are seeking authority to make pre-petition payments on account of their non-insider severance programs that constitute priority treatment under Section 507A of the Bankruptcy Code, as well as to honor post-petition non-insider severance obligations in the ordinary course solely as required by applicable law. As indicated, the debtors are not seeking authorization to pay severance to any quote-unquote insider as such term is defined under Section 101.31 of the Bankruptcy Code. In connection with those payments, the proposed order now includes reporting requirements, and this information will be provided on a monthly basis to the U.S. trustee, any secured creditors committee appointed in these cases, as well as the DIP lenders. Prior to filing the motion, the debtors previewed the requested relief with the U.S. trustee's office and answered certain questions, and I also understand that we are resolved on the questions they posed and that the U.S. trustee does not object to the order. Unless Your Honor has any questions, we respectfully request that the court approve the wages motion and enter the order.
All right. Does anyone wish to be heard with respect to the wages motion?
Your Honor, this is Hal Winston, the U.S. Trustee's office.
Yes.
Counsel's correct. We are resolved, but I just want to make this reservation on the record. I don't want to put a stop to people's retirement plan at this time, but there are certain supplemental executive retirement plans within the wages motion. We just want to reserve rights. Once we get more information, it violates 503C. We wanted to take a look at it and preserve those rights. But in terms of the interim orders, we don't oppose entry of the order today.
All right, thank you. All right, anything further? All right, I've reviewed the motion, and obviously there's a lot of employees and the numbers are big, but obviously keeping the employees is a key part of preserving value in this company. So I think this is proper exercise of the debtor's business judgment. I'm going to go ahead and approve the wages motion. So if you give me a minute. All right, that has been signed and sent to docketing.
Thank you, Your Honor. Next is agenda item number 8, which is the customer programs motion. This appears at docket number 15. Like many large retailers, the debtors have historically implemented certain customer programs to promote customer satisfaction, create goodwill for their businesses, and enhance the value of their brands. The debtors' specific customer programs are described in detail in the motion and include refund and exchange programs, gift card programs, credit cards, and loyalty and rewards programs, among others. The debtors are seeking authority to honor pre-petition obligations related to their customer programs, subject to the amounts set forth in the motion, and to continue their customer programs in the ordinary course. Honoring these customer program obligations and continuing the programs in the ordinary course is critical to preserving the ongoing value of the debtors' operations during these cases. Prior to filing the motion, the debtors previewed the requested relief with the U.S. Trustee's office. We incorporated requested language into the proposed form of order, which appears in paragraph 4 of the order, noting that in the event that the debtors choose to terminate any gift cards, they will provide sufficient notice to parties in interest, including by posting a notice on their website and at the store's locations. For the avoidance of doubt, the debtors seek to continue their gift card programs pursuant to the relief requested in the motion. With this inclusion, we understand that the U.S. Trustee does not object to the order. Unless Your Honor has any questions, we respectfully request that the court approve the customer programs motion and enter the order.
All right. Mr. Hess, I think you filed a reservation of rights.
From behalf of Capital One. Capital One is a party to Neiman's and Bergdorf Goodman with regards to the private label credit card agreement. As a general matter, Capital One does not object to the continuation of the program. There is kind of a nuance that they have objections to. That relates to
what's described in our objection as the recourse credit obligation, that the program that provides their customers that purchase goods in excess of their credit lines, that Neiman's has the obligation to backstop those guarantee and agree to repurchase them. We've asked that be suspended for the time being so that there's no further increase in the recourse obligations of Neiman's, and that we can wind down the existing outstanding obligations. We have submitted to the debtor proposed language before the hearing, but there's a lot going on, and we have not heard back from them, and so we're hoping that is inserted into the order. So, subject to that limited objection, we stand by objection.
Apologies, Your Honor, we did miss it, but we will review after the hearing and get back to Mr. Hess.
All right. So, again, anyone else wish to be heard? All right. So I've reviewed the customer program motion. Obviously, the employees and customers are key participants in making this case a success. So I've reviewed the motion in form of order, and I'm going to go ahead and approve the motion to the customer programs motion at docket number 15. So I'll wait for the revised form of order. Just make sure to contact Mr. Laws once that gets filed.
Thank you, Your Honor.
So that is granted.
Thank you, Your Honor. The next item on the agenda is item number 9, which is the taxes motion, and this appears at docket number 8. By this motion, the debtors are requesting authority to pay taxes and fees that they owe to relevant state, local, or federal taxing authorities. As set forth in further detail in the motion, given the sheer size of the debtors' operations, the debtors are responsible for a variety of taxes and fees, including sales and use, income and franchise, license and regulatory, property, and customs duties, among others. As of the petition date, the debtors estimate that they owe approximately $134 million in taxes and fees, which includes amounts incurred on behalf of audit. None of the taxes that the debtors are seeking authority to pay represent old unpaid taxes. Prior to filing the motion, the debtors previewed the requested relief with the U.S. Trustee's Office and incorporated requested language into the proposed form of order. This language appears in paragraph 13 and notes that the debtors will provide reporting to the U.S. Trustee's Office and on a professionalized only basis, counsel to the DIP lenders and any committee appointed in these Chapter 11 cases. With this inclusion, we understand that the U.S. Trustee does not object to the order, and unless Your Honor has any questions, we respectfully request that the Court approve the taxes motion and enter the order.
All right. Does anybody else wish to be heard on the taxes motion? All right. I'm going to go ahead and approve the taxes motion. I think that obviously most of the taxes are priority claims, and in effort to avoid penalties and potential implications for responsible persons, it's in the debtor's business judgment to go ahead and pay the taxes. So give me a minute here. All right, that order has been signed and sent to docketing.
Thank you, Your Honor. Next up is agenda item number 10, which is the insurance motion, and this appears at docket number 9. Through this motion, the global debtors are seeking authority to maintain their insurance policies in the ordinary course, pay any pre-petition amounts thereunder, and honor the current surety bonds and letters of credit. As set forth in the motion, the debtors maintain 154 insurance policies administered by various carriers, which includes coverage for property damage, general liability, D&O liability, cybersecurity, and among other coverage. The debtors are also party to 4 premium financing agreements. All but one of these policies has been paid in full as of the petition date. The debtor's next payment under the cyber policy premium financing agreement is due at the end of this month. The debtors maintain 40 surety bonds in the approximate amount of $11.6 million, and these relate to utilities, customs, taxes, different security deposits, and liquor licenses. The global debtors also maintain various letters of credit for the benefit of third parties to support their obligations related to, among other things, workers' compensation, property leases, inventory, and transportation logistics. The debtors believe that the maintenance of insurance coverage is not only essential to continued operation of the debtors' businesses and preservation of the debtors' estates, but also required under the trustees' operating guidelines. Prior to filing the motion, the debtors previewed the requested relief with the U.S. Trustee's Office, and we incorporated language into paragraph 7 of the proposed order. This language notes that the debtors will notify the U.S. Trustee if they seek to renew, supplement, or modify their insurance policies, surety bonds, or letters of credit, and seek to obtain replacement coverage during the cases. I understand that we are resolved and that the U.S. Trustee does not object to the order. Unless Your Honor has any questions, we respectfully request that the Court approve the insurance motion and enter the order.
All right. Does anyone wish to be heard on the insurance motion? All right. Again, the insurance motion obviously is required. Insurance is required by the U.S. Trustee guidelines. In addition, it's a proper exercise of the debtor's business judgment. So I will go ahead and approve the order allowing you to proceed with the insurance program. So give me a minute. Okay, that order has been signed and sent to docketing.
Thank you, Your Honor. I will now cede the podium to my colleague.
Okay, just to make sure, I want to, so with respect to the, so the cash management order you had, you're going to upload a new order, is that right?
Yes, that's correct.
Okay. I think that's the only one, right?
Yes, right. Oh, and the customer program.
Okay, got it. Okay. All right. Thank you.
Thank you, Your Honor.
Hi, good evening, Your Honor. For the record, Allison Smith, Wilkie Barton Gallagher, proposed counsel to what we've been referring to as the global debtors.
Yes.
I'll pick up right where Ms. Graber left off with agenda item number 11. It's the global debtors critical vendors motion. It was filed at docket number 14. The global debtors are seeking authority to make payments to trade and 503b9 claimants in an aggregate amount up to $126 million on an interim basis and approximately $337.4 million on a final basis. I do recognize, Your Honor, that on its face, these numbers do err on the higher end of the scale. But as I'm sure you can appreciate, both from our documents and the statements that have been made on the record already today, these relationships and these creditors are very, very important to the debtor's business. And it's a business whose success is directly influenced by, of course, their ability to stock and carry inventory. It is critical to this process and the go-forward operations more generally that the global debtors be able to restart those vendor payments and shipments to ensure that they can continue providing the diverse and uniquely curated inventory assortment to which their customers have become accustomed. We did engage with the U.S. Trustee's Office prior to filing. I understand that we have addressed and resolved their concerns largely by the inclusion of the standard reporting matrices obligations. I'm happy to address any point in particular, but unless the Court has any questions, would submit that the specific facts and circumstances of these cases do justify and support the relief being sought, and the motion be approved on an interim basis.
All right. Anyone else wish to be heard? All right. Again, the vendors are just as important in this case as the customers and the employees, and so I think this is a proper exercise of the debtor's business judgment. I'm going to go ahead and approve the order. Let me just give me a minute. All right, that order has been signed and sent to docketing.
Thank you, Your Honor. Moving to the next item on the agenda, the lien claimants motion at agenda item number 12. This motion was filed at docket number 16. Similar to the critical vendors, the parties contemplated by this motion are those parties that are necessary to maintain an uninterrupted flow of inventory and other goods to the debtors' networks and to their stores and customers. In addition to ceasing services, which would cause disruption and delay to the debtors' operations, these parties may be entitled to assert liens on the debtor's property as a result of non-payment. Accordingly, the debtors are seeking authority to pay up to approximately $114 million. Again, these payments are crucial to turning the spigot back on, so to speak, so the debtors can resume, ordinary course operations and inventory sourcing as they transition into these proceedings. Unless Your Honor has any questions for me, I would ask that the court enter this order.
All right. Does anyone wish to be heard with respect to the lien claimants order?
Your Honor, this is Howland from the U.S. Trustee's Office.
Yep.
Can I be heard?
Yes, sir.
My only concern with this motion, I think I raised it with the debtors, is that you're granting on a final basis of approximately $114 million on day one. I'm very concerned about that. It's a big case, and I understand it's a big number, but in terms of not having a committee, not having more eyes on the amount, the critical vendor motion is also a big number, but then you get trade agreements, you get a final, and there's procedures to actually look into the numbers. So once this order is entered, $114 million of estate assets, it will be leaving, and I don't doubt that there are needs for it, but my only concern is I don't have a committee in place yet to take a look at these numbers, and my suggestion was to bifurcate the process in a way that what they need in the next, 3 weeks until we get into a second day hearing, as opposed to having final approval of $114 million today on less than 24 hours of notice.
The only thing I'll say to that, Your Honor, is that a number of these claims subject to this motion do give rise to secured claims that would be paid out later in these cases regardless. And we have incorporated the same matrix and scheduling reporting obligations, and of course we're happy to provide that to any committee that is appointed in these cases.
All right, so I'm going to go ahead and grant the motion on a final basis, but obviously the debtor is going to pay these. They're not going to pay these all at once, and to the extent that the committee wants to raise a question with respect to the timing of the payment or the necessity of the payment, I'll allow them to raise that at the second day hearings. But I think these are different than critical vendors. Critical vendors, you have to negotiate a trade agreement. You have to do those kinds of things. To the extent these are lien claimants that can actually hold disrupt your supply chain, I think that I'm inclined to grant the relief. I don't think, in fact, that the debtor doesn't have sufficient cash in order to be able to pay these all on day one. They're authorized to do it, but they're authorized but not directed. So I think that they will be paid in the ordinary course. I'm sure the debtors will act prudently in terms of how they're going to handle this. So on that basis, I'm going to approve it. But again, to the extent the committee sees this differently than the debtor, obviously they're going to have the opportunity to raise that issue. So on that basis, I'm going to go ahead and grant the order as drafted.
Thank you, Your Honor. I'll allow my colleague to take you through the remainder of the motion.
All right.
Good afternoon, Your Honor. Zachary Charlton. For the record, Wilkie Farn Gallagher, proposed counsel to the Global Debtors. Can you hear me okay?
I can.
Perfect. I'm going to be addressing agenda number 13, which is docket number 12, the automatic stay motion. The debtors operate as a global enterprise, and importantly, as referenced in connection with the critical vendors here, the debtors have regular dealings with foreign customers, contract counterparties, vendors, and foreign governmental units, without which the debtors' services would be severely disrupted. It's likely that these foreign vendors are unfamiliar with the automatic stay and its application, and as such, various interested parties may attempt to seize assets located outside of the United States to the detriment of the debtors, their estates, and creditors, or otherwise attempt to contravene the provisions of the Code. This order seeks to notify parties of the stay. We believe the motion and the proposed order simply restates and does not expand the protections under Section 362 of the Bankruptcy Code. We shared this motion and the proposed order with the United States trustee prior to the hearing, who indicated no comments to the form of order. Unless the court has any questions, we'd respectfully request entry of the automatic stay order filed at docket number 12.
All right. Does anyone object to the entry of the comfort order? All right. I've reviewed the proposed form of order. I think it does restate what the automatic stay indicates, and to the extent that you have a global enterprise, I think it's important to make sure that all of the assets of the estate are protected. So I'm going to go ahead and enter the comfort order.
Thank you, Your Honor.
All right, that's been signed and sent to docketing.
Thank you, Your Honor. Next up, we have agenda item number 14 at docket number 6, which is the utilities motion. By the utilities motion, the debtors are seeking entry of an order approving the proposed adequate assurance of future utilities, prohibiting utility companies from discontinuing, altering, or refusing service, and approving the proposed adequate assurance procedures. Utility companies provide services vital to the operation and management of the debtors' brick-and-mortar locations and distribution and fulfillment centers. Further, the debtors contract with various third-party administrators to process the debtors' utility invoices and payments. Any interruption of the utility services would significantly disrupt this case and impact the debtor's ability to sell merchandise and operate as a going concern during these Chapter 11 cases. Adequate assurance has been provided in the form of the debtor's newly established utility deposit account, which holds $2.9 million, representing 50% of the debtor's estimated monthly costs of pre-petition services. Your Honor, we believe the relief requested is proper under Section 366 of the Code and is standard in cases of similar size. We do have a few revisions we plan to make to the proposed utilities order. We received comments from the debtor's landlords and will add language to the order affirming that the proposed order will not bind landlords under Section 366 of the Code and that all of the landlord's rights are preserved under Section 365. Additionally, we will remove certain landlords that were inadvertently listed on Exhibit 1. We've shared the proposed order with the United States trustee and received no objection. Our motion and order otherwise incorporates the U.S. trustee's comments. As such, Your Honor, unless you have any questions, we would respectfully request that the court enter the proposed order.
All right. Does anyone else wish to be heard on the utilities motion? All right. I have reviewed the motion and the proposed form of order. I will approve the motion. I think under 366, the way I read 366, you have to have, if somebody requests additional adequate assurance within the first 30 days, you have to have a hearing. So what I'm going to do is, and this is not, I'm going to say, since the first case was filed on the 13th, 30 days would be February 12th, 30, yeah. So I have a hearing starting that day at 9. So I'm just going to schedule a 30-minute at 8:30 to the extent, just limited to the extent anyone requests additional adequate assurance between now and that date so that we could come in and do it. I anticipate that it won't happen, but I think 366 says we have to do it within 30 days. And so I'm going to go ahead and just pencil that in to have it. But otherwise, I'll go ahead and grant the proposed form of order, the proposed form of motion, and then I'll await for your order.
Thank you, Your Honor. Next on the agenda, we have item number 15, the Schedules and SOFAs extension motion, which was filed at docket number 4. By this motion, the debtors seek entry of an order extending the debtors' deadline to file their schedules and statements and 2015.3 reports by 45 days to March 13th, that being 59 days after the petition date. The global debtors submit that cause exists to extend the schedule and statements deadline and the 2015.3 reports deadline, given the voluminous number of books, records, and documents that the debtors' complex accounting systems across various legal entities located in numerous jurisdictions. Finally, the global debtors submit that good and sufficient cause exists to modify the requirements of Local Rule 2015-3 to permit the global debtors to file their 2015.3 reports every 6 months rather than monthly as required under the local rule. A monthly compilation of these materials for all non-subsidiary operations would demand an excessive administrative cost to the global debtors, their advisors, and their employees. Notably, the global debtors do not seek a full waiver of their obligations to file the 2015 reports. Rather, the global debtors seek permission to file the 2015.3 reports every 6 months instead of every month. Accordingly, there will be no harm to any parties in interest here, as they will still receive the necessary information. We would note, Your Honor, that the relief requested herein is consistent with relief typically granted by courts in this district in complex Chapter 11 cases, especially one of this size. And, Your Honor, based on the foregoing, and unless you have any questions, I would respectfully request that you enter the requested relief.
Mr. Wynn?
Howland for U.S. trustee. No objection, Your Honor. I would not require them to file their schedules within 14 days. I think the extension makes sense for these debtors.
All right. So, again, I've reviewed the proposed form of order. I think in the case of this size, I think the requests are appropriate. So let me... Mr. Wynn would normally require you to do that within 14 days, but he's being nice today.
Thank you, Mr. Wynn.
All right, that order has been signed and sent to docketing.
Thank you, Your Honor. With that, I will cede the podium to our colleagues at Haynes and Boone to continue with the agenda.
All right.
Thank you.
Good evening, Your Honor. David Scott, Haynes and Boone, proposed co-counsel to the global debtors. The next item on the agenda is item 16, the creditor matrix or redaction motion filed at docket number 7. In this procedural motion, the debtors seek approval of 3 things. Using a single top 30 list and consolidated creditor list, the form and manner of notice of commencement of these cases, and the redaction of personally identifiable information. For the first, using a single top 30 list and consolidated creditors list is consistent with the complex procedures and customary practice in this district for large cases like these. For the second, the debtors submit that the form of notice attached to the proposed order is Exhibit 1. It complies with complex case procedures and is also customary for cases like these in this district. And then lastly, we seek authorization to redact personally identifiable information. As the court knows, privacy concerns are paramount in today's world, and the requested relief is narrowly tailored to balance the competing interests between transparency in these cases and privacy concerns of individuals that are brought to these cases involuntarily. We incorporate comments received from the U.S. trustee in the proposed order, and I believe they're signed off on the proposed order, so unless the court has any questions, we request entry of the proposed order filed at docket number 7-1.
All right. Does anyone wish to be heard with respect to the redaction motion? All right. I've reviewed the motion and the proposed form of order. And again, I believe this is a proper exercise of the debtor's business judgment. I think the concerns raised by Mr. Trosh are genuine concerns, especially with respect to the privacy issues and the administrative convenience. I think that's being done with no similar. There's no harm to any of the creditors as a result of this. So all right, I've signed that order and sent it to docketing.
Thank you, Your Honor. The next item on the agenda is item number 17, the debtor's joint NOL and record date motion, which was filed at docket number 11. This is also a procedural motion, Your Honor, which the debtors seek approval of two things: procedures governing certain transfers of equity interest in the debtors and declarations of worthlessness for tax purposes with respect to equity in Debtor Sachs Global Holdings LLC, and then also a record date for potential sell-down procedures applicable to transfers of debt claims against the debtors. The purposes of these procedures and the record date is to ensure that the debtors can adequately protect against the loss of their substantial tax attributes, which are property of the debtors' estates. Trading of equity interest in the debtors during these cases could cause an ownership change to occur that would adversely affect the debtors' ability to use their tax attributes. The procedures detailed in the motion set forth restrictions on the transfers of stock in the debtors and the declarations of worthlessness with respect to equity in Debtor Sachs Global Holdings LLC to avoid a transaction that would be irreversible for tax purposes and destroy the debtor's valuable tax attributes. The motion also seeks approval of a record date to put parties on notice that the debtors may need to seek a sell-down order for any debt claims acquired after the record date. We're not seeking a sell-down order today, Judge. We're only seeking to establish the record date so that if the debtors have to seek a sell-down order, the debt claim holders are already aware of the record date for purposes of the sell-down order. Because certain changes to the debtor's equity structure and post-record date debt claims trading could threaten the debtor's valuable tax attributes, the debtors believe that this relief is in the best interest of their estates and all parties in interest. The proposed procedures are customary practice in large Chapter 11 cases that balance notice and latitude for trading stock and the debt claims while at the same time protecting valuable estate assets. We previewed the motion and proposed order with the U.S. trustee and did not receive any comments. So unless the court has any questions, we respectfully request entry of the proposed order filed at docket number 11-1.
All right. Does anyone wish to be heard on the NOL motion? All right. So again, I reviewed the proposed form of order and the motion. The debtor has billions of dollars of tax attributes, and I think this is only prudent for the debtor in an exercise of its business judgment to protect those assets, which are in fact property of the estate. So I'm going to go ahead and approve the motion.
Thank you, Your Honor. That concludes my portion, and I'll pass the virtual podium to the Bradley team.
All right. So that order has been signed and sent to docketing. All right, Mr. Martin, don't tell him not to put you last.
Say the best for last, Your Honor. Your Honor, before I begin, a few housekeeping items. First, I want to move to admit two exhibits. First is Exhibit 12, which is the declaration of Andrew D.J. Heed in support of SO5 Digital Debtors Chapter 11 petitions and first day pleadings.
All right. Anyone object to the declaration of Mr. Heedy? And that is at docket number 12. No, I'm sorry, it's not. It's docket number.
It's docket number 37.
Docket number 37, in connection with the two matters for the what I call the digital debtors. All right, hearing none, I'll admit that as his direct testimony.
And the second exhibit, Your Honor, would be the admission of Exhibit 14, which is our initial cash collateral budget.
All right. Does anyone object to the admission of the initial cash collateral budget? It's a 3-week budget, right?
Yes, Your Honor, but we'll be asking to come back in 2 weeks.
Okay. All right. So it's a 3-week budget. Does anyone object to the admission of the budget for the what I would call the digital debtors? So that exhibit, which is attached to exhibit number 14, is admitted.
Thank you, Your Honor. Next, Your Honor,
Go ahead.
I just wanted to note for the record that as the Wilkie team went through their first day motions, much of the relief that was requested in those motions is joint relief as it relates to the SO5 digital debtors. It would be very unusual for a case of this size to only have 2 first day motions. Right. That's because we, for efficiency purposes, joined in much of the relief that was being requested by Saks Global.
Right.
Your Honor, the first motion I'd like to go through is the cash collateral motion. The SO5 digital debtors need the use of cash collateral to avoid irreparable harm. Absent the use of cash collateral, they would not be able to continue on in their business in the ordinary course. The debtors' secured creditors are represented by Caledine Commercial Finance LLC as pre-petition agents, and Morgan Lewis is their counsel. Your Honor, I'd like to go through some of the provisions of the order, and if the court has any questions as I go through it, I'd be happy to answer them.
No, hold on. I have it. All right, why don't you go ahead? I just want to make sure I understand paragraph number 9. In paragraph number 17, the amount for the challenge is $50,000. I don't know whether that's an appropriate amount. Obviously, that's going to be and it's also $50,000 in the dip motion, which is probably not an appropriate amount, but I don't know whether this is it. Obviously, that's without prejudice to the committee coming in and asking. And then,
paragraph 9, Your Honor.
I really, the only question I had was really, I want to make sure I understand paragraph 9, but other than that, I really didn't have any questions. All of my other tabbies I answered myself.
Understood, Your Honor. I think just for the benefit of everyone, because some of these terms were negotiated, I would like to get that on the record if the court is okay with that.
Absolutely.
The primary item I wanted to note for everyone relates to the cash collateral budget during the interim period. The budget contemplates establishing an escrow of $350,000 relating to amounts that may be paid to the Saks Global debtors as it relates to fees and expenses that they may be covering that are for the benefit of the SO5 digital debtors. As the court is aware, through the first day declarations of Mr. Weinstein and Mr. Heedy, the SO5 digital debtors consolidated their operations with the global debtors back in 2021, and since that time have been operating under a sharing agreement. That sharing agreement contemplated the certain expenses to be reimbursed to the Saks Global debtors, and now that we're in bankruptcy, the analysis now needs to change to whether those expenses are reasonable and necessary under 503B. And so what this does is it creates a framework for funds to be set aside so that if there is an administrative expense claim between the estates, that there's a mechanism to tee that off. And this is, I think, the first agreement relating to that, and I'm sure we'll be revisiting that again in the next interim order and in the final order. So I just wanted to preview that for the court.
Where is that in the budget?
It's the TSA payment at $175,000 per week.
All right. Was there an updated budget? Because the budget I have, is that, I know you filed a revised form of order. Is it attached to that?
If it's not, I'll make sure it is. I don't have it up in front of me right now.
Okay, because the Saks Global TSA payment is zero. There's no amount in the budget that I have.
Then that must not have been updated, so we'll make sure that the updated budget gets attached to the final proposed order that's been filed with the court.
All right, thank you. All right, does anyone else wish to be heard with respect to the SO5 digital debtors. All right. So again, obviously, these debtors need to have cash collateral, access to cash collateral. I think the form of order is perfectly appropriate. I think it has the, with respect to both the events of default and the challenge period, I think it has the standard language with respect to those. So I'm going to go ahead and approve the cash collateral for the 5.0 digital debtors. I did get a revised form of order at docket number 77, and let me just see.
And then, Your Honor, I believe there's another revised form of order at docket 141.
Well, that must have started. That must have been.
And I see that the approved budget wasn't attached, so we will re-upload that order with the approved budget.
All right, so I'm going to go ahead and grant them. Yes. Yes.
Your Honor, can I be heard? Brendan Scott of Clayside, Wonders, Struthers, Southern Stevens, again on behalf of BH Multicom, BH Multicolor, Richland Designs, and Unique Designs.
Yes.
I'm speaking only because I have similar concerns that we raised with respect to the DIP motion regarding the preservation of consignment vendors' lien rights or consignment rights. Is there going to be similar language, a reservation as similar to that in paragraph 27 of the DIP order included in the cash collateral order?
We have no objection to that, and the intent is to preserve all rights of consignment parties.
Thanks. I mean, to the extent, I think that resolves any objection we would have with respect to pre-petition consignment goods delivered pre-petition, but we also proposed some language related to post-petition delivery of consignment goods that was designed really to try to prevent an interruption in the debtor supply chain. We have proposed language that would give consignment vendors comfort that goods delivered post-petition are not going to be challenged, and there's going to be some certainty that those goods are not going to be viewed as property of the state, and that otherwise consignment vendors would have perfected consignment rights on those goods. We don't want to be in a situation where we're delivering goods and then we get to a final hearing only to find that somebody wants to challenge our rights with respect to goods that were delivered post-petition. Pre-petition, I think, is a different story. Whatever rights we have are the rights we have. My clients are happy to and hoping to support these debtors in the post-petition period, but I think they're also looking for some comfort that to the extent they do deliver goods, they're going to have protection, and they're not going to have someone coming in and challenging their rights. So we had presented some language to the debtor that would provide for essentially automatic perfection of consignment rights to the extent people were delivering goods on consignment, and it was clear that they were delivering goods on consignment. We hadn't received a response from the debtors. I know that we're juggling a lot of balls, but I don't know how to deal with that at the moment. Typically in the old days, you might step outside and try to talk through something in the hallway. But is it possible, Your Honor, we could just put this on hold for a few minutes and we could resend that language to debtors' counsel?
So,
Your Honor, I'm happy to review any proposed language.
Yeah, this is an interim. This is an interim order. I think your request is a reasonable request. So they're going to have to upload another order anyway. So I'm going to go ahead and approve it. And then to the extent there's an issue with respect to the language, I'll take that up. And it would be, it would be as of the when we go to the final hearing. And then when did you want a final hearing on this? You said 2 weeks.
Yes, Your Honor. Do you have anything available on or around January 27, 28?
Hold on a second. Let me see. I'm just communicating with Mr. Laws. Just give me a minute.
Thank you.
Could you go out to the 23rd? Or is that too long?
I defer to Mr. Carter as to whether the budget can be extended to the 23rd. Are you talking about February 23 or January 23?
I'm talking about January 23rd.
Okay. That's within our 2-week period, and that works for the debtors.
All right, so we're going to do January 23rd. And that will be a virtual setting.
Thank you, Your Honor. And before we go off the topic of cash collateral, I wanted to make sure I answered any questions that the court had regarding paragraph 9, which is the application of proceeds of post-petition collateral.
No. I think I understood kind of what's going on now.
Okay, thank you.
All right. So I'll go ahead and grant the motion, subject to the language that we're going to get, and with respect to making clear that with respect to consignment, those assets on a post-petition basis are not becoming part of the collateral base, and that on the pre-petition, everybody's reserving their rights.
Thank you, Your Honor. And with that, I'll turn the podium over to James Bailey relating to the SO5 digital debtors cash management motion, which tracks generally with the cash management motion that the court already approved for the global debtors.
All right. Go ahead, Mr. Bailey.
Thank you. Good evening, Your Honor. James Bailey with Bradley Aram Bolt Cummings, proposed counsel for the SO5 digital debtors. Your Honor, much like the global debtors, the digital debtors just need this straightforward relief to ensure continuity of operations, maintain control and transparency over cash, and avoid disruption on the first day of these Chapter 11 cases. Your Honor, prior to the petition date, the SO5 digital debtors operated a cash management system using established bank accounts and ordinary course collection and disbursement procedures. That system has been in place for a significant period of time. It's well understood by management and includes internal controls designed to safeguard state funds. Your Honor, there is a request to continue intercompany transactions in the cash management order. That would be in the discretion of the SO5 digital debtors, of course, with any payments being consistent with the cash collateral order and budget. Your Honor, we also requested certain waivers of the U.S. trustee operating guidelines and the timeline to comply with Section 345. Your Honor, these are customary, reasonable, and necessary relief to ensure a smooth transition in these cases. We have previewed the order, motion and order, with the U.S. trustee, who I understand has no objections. Your Honor, I think that this would go out to the February 13 second hearing date with the same objection deadline tracking the global debtors motion. I'm glad to answer any questions, Your Honor.
All right. Does anyone wish to be heard on the SO5 debtors cash management motion? All right. I've reviewed the motion and proposed form of order, and again, I think this is a proper exercise of the debtor's business judgment in allowing them to have the uninterrupted use of their cash as opposed to shutting everything down and starting all over again. So I'm going to go ahead and grant the motion. So give me a minute. All right, I've signed that and send it to docketing.
Thank you very much, Your Honor. I believe with that I would cede the podium back to the Global Debtors Council. Thank you.
All right. Why don't we come back and let's take a 10-minute break. Why don't we come back in at 6:50, and we'll proceed with the dip at that time.